Sully, a partner in Husch Blackwell's education group, and I'm here with two of my partners in the group, Derek Teeter and Michael Raup. We're excited to be with you today, and thank you for joining our discussion of the Supreme Court's recent decision regarding race-conscious admissions practices in higher education. Before we begin, I'd like to cover a few housekeeping items. At the bottom of your audience console are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit those via the question box. We will try to answer questions at the end of the discussion if time allows, and if necessary, we are happy to follow up with you after the conclusion of the webinar. A PDF of the presentation is available in the Program Materials folder. This program has been approved for legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including the course number, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Towards the end of the program, please be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your needs, so we really appreciate your responses to those surveys. That's all for the housekeeping items, so let's begin with our program. Michael, I'm happy to turn it to you to get us started with some background about the two admissions programs that were the subject of the recent decision.
Thanks, Julie. I appreciate it. Good to be with everyone today. And yeah, I think to sort of frame up our discussion today, it's important to understand the programs that were at issue at both Harvard and North Carolina that they were utilizing for their admissions process prior to the Supreme Court cases. So let's start with Harvard. At Harvard, there was an initial first read process where all of the applications are considered by members of the admissions staff. And they had 6 qualitative and quantitative categories that were scored 1 through 6, 1 being the best, 6 being the worst, in 6 different categories. Once those applications were scored, it then went to a subcommittee process. And in that subcommittee process, certain groups would evaluate all applicants from different geographical regions throughout the country. And those subcommittees would make recommendations to the full admissions committee. At both of those first 2 stages, the record demonstrated that race of candidates can and was considered in making recommendations and in the scoring process. Things then went to the full admissions committee, all of those recommendations. At the full admissions committee, they began that process with a breakdown of applicants categorized by race to ensure that there wasn't a substantial drop-off from the prior year's admissions numbers for minority applicants. When those recommendations were considered at this full committee level, each candidate was considered one by one and voted upon by the full admissions committee. And then at the end of that process, once all of the those that made it through were the tentative admissions class was set, at that point, the racial composition of that tentatively admitted class was disclosed to that admissions committee. Then finally, they went through a last step, which they called the LOP process, where that list is narrowed down to arrive at the final class. And for each applicant that's considered in that process, whether they'd be included or whether they would be lopped off of the final admit list, there were only 4 pieces of information that were disclosed to the committee: legacy status, recruited athlete status, financial aid eligibility, and race. And at that point, they would complete that LOP process. And once that was complete, the class was set. So that was the process as the Supreme Court outlined Harvard's process. North Carolina's was a more abbreviated process. The way the court described it is that each application was initially reviewed by one of about 40 admissions officers at the university. And those admissions officers were required to consider race and ethnicity as one factor in that evaluation process. So after assessing the application, those admissions officers would then create a comment in the application about a recommendation, about whether this person should be admitted to the university or not. And race could be considered as a plus factor in that process. Once that's done, those decisions at North Carolina were close to final. but it would go to a review committee, which would approve or reject the recommendations. And at that review process, that committee could consider race as well. So while we see some variation in the technical aspects of how these two institutions implemented their admissions policies, these are what we refer to as holistic admissions policies. In other words, there aren't specific racial quotas. Rather, race is considered as one factor among many when making the admissions decisions in these various processes.
Michael, I'm going to move you on to the claims that the plaintiffs were raising when the cases were first filed.
Sure. So both of these schools were sued by an organization called Students for Fair Admission. And it's an organization that was advocating for race not to be considered in admissions decisions. And just as a brief side note, because you'll see some discussion of this in the opinion itself, the Supreme Court and actually the lower courts had evaluated whether this organization was one that had the legal standing to bring this type of claim. And all the courts to consider that question eventually concluded that they were. So that's why you see this brought by an organization and not, as we've seen in some of the other cases, by specific individual students that were looking to gain admission. But after the trial in the lower courts, both of the programs that we just described, Harvard's and North Carolina's, were upheld under the Supreme Court's prior framework. The Supreme Court obviously agreed to review those decisions, and there are really two claims that are at issue here. First, University of North Carolina was sued for violating the Equal Protection Clause found in the 14th Amendment of the Constitution. But that clause only applies to public institutions. So with respect to Harvard, it was sued, and North Carolina was sued as well, under Title VI, which is the federal statute that prohibits any discrimination on the basis of race for any school that's accepting federal funding. So there's some confusion, and there was some confusion shortly after the opinion came out, because as you read it, the opinion really talks just in terms of the Equal Protection Clause or the constitutionality of these programs. And that's how, when you read about this in the media, that's how a lot of this is being characterized. And Chief Justice Roberts, in the majority opinion, explained this in footnote 2 of the opinion. If anybody's interested in looking at it specifically, he described that Title VI really operates as in the same way that the Equal Protection Clause does. In other words, if we find that you're violating the Equal Protection Clause, by definition, you are also violating Title VI. So for purposes of this opinion, the analysis really collapsed into one, and the opinion speaks in terms of the constitutional challenges. So that, just to set the stage then for what we're talking about, because this becomes important when we look at the framework that the Supreme Court has used throughout these cases, and what it used in this case is an equal protection challenge. And what that means is that any distinction that's made on the basis of race must survive what the court refers to as strict scrutiny. And that's a two-step process. First, we ask whether the racial classification is used to further what the court refers to as a compelling government interest. And second, then, whether the program is narrowly tailored to achieve that interest. And we'll speak a little bit more, especially throughout this presentation, about that compelling interest, because that's really a lot of where this analysis turned in this opinion. But the thing to appreciate about this test, it is one of the most stringent tests to meet under the law, and certainly in constitutional law, it's the most stringent test that the court applies. So it's very difficult to overcome, and that's the framework under which the court was analyzing this opinion.
Michael, can you give us a little bit of background? It's a tall order. The prior legal framework that we had been working under up until these cases had come along.
Yeah, everybody's probably sick of me droning on already, so I'm not gonna go through each one of these point by point, because we could be here for the full hour discussing the history of all this jurisprudence. So the four sort of critical decisions in this space are listed there on the screen. And so this is not obviously the first time that the court had encountered these issues. And these opinions are discussed in the court's opinion too. What's important to understand sort of at a high level about where the court went through these decisions from 1978 through 2016 is that the court consistently recognized that there was a compelling interest. Again, that's the critical point in the strict scrutiny test. There was a compelling interest in the educational benefits that flow from a racially diverse student body. So while each of these four cases considered it in slightly different contexts, and there's different rhetoric around all of those decisions, that compelling interest was recognized throughout that line of authority. And so I will say throughout those cases, the court did start to narrow its focus, probably is fair to say, on the circumstances in which race could continue to be a proper factor to consider in admissions decisions. But in each of those decisions, the court did reaffirm that diversity or the educational benefits flowing from a racially diverse class qualified as a compelling government interest. And it's really that underpinning of those decisions that was sort of the key aspect of the opinion when Harvard and North Carolina came to the Supreme Court.
Thanks, Michael. Why don't you get us into the shift that the Supreme Court just took away from the prior jurisprudence?
Sure. So as is not breaking news at this point, the court did hold that the race-conscious admissions programs violated the Equal Protection Clause. And as I mentioned earlier, this applies equally in that Title VI analysis too. So for all intents and purposes, public institutions, private institutions, as long as they're accepting federal funding, treated under the exact same framework for purposes of what the court has done here. And the court identified, the majority opinion identified several bases to invalidate these admissions programs. It was a 6-3 decision with the opinion being authored by the Chief Justice. And I'll go through them briefly here. They're listed on the screen. And, whether there's 4, 5, 6, you can slice them different ways. But I think these are really the key takeaways. And what this gets back to is that compelling interest point that we were talking about, and whether diversity can continue to withstand that scrutiny. And the Chief Justice, in his opinion, explains that it cannot. First is that the asserted compelling interest, again, educational benefits flowing from diversity, is too vague. The court described it as being not measurable, that courts couldn't meaningfully review those goals to know when they had been met. So in other words, when a program would be necessary anymore or not. And again, these are the same asserted interests articulated the same way as the prior Supreme Court case law had evaluated. So that first top line holding is that same asserted diversity interest is no longer a compelling interest because they are too vague in terms of how they're framed. Second, the admissions programs, the categories that are used are overbroad and under-inclusive. And what the examples that the court gave for overbreadth would be, for example, grouping all Asian students into one racial group for purposes of analysis, and under-inclusive, and the example they gave there was Middle Eastern students may not fall within one of those defined categories that the schools were using. And the point of the court raising that over-inclusive or under-inclusiveness is that there's not a meaningful way then to illustrate a match between those categories that they are utilizing and the asserted compelling interest of the educational benefits flowing from the diverse class. Third, and this is an important point in how the court, I think, framed up this whole discussion, is that these admissions processes were zero-sum at these institutions, meaning that race operates as a negative for some students. Now, the school's argument, contrary to that, is that race is never a negative in our holistic admissions process. It's only used to provide as a positive factor or something that can positively impact some students. But because the admissions process at these institutions is zero-sum, meaning it's a competitive admissions process where not everyone gains admission, by definition, that negatively impacted others who were not provided that same plus factor through that process. Fourth, the school's admissions programs inherently necessitated the use of stereotypes. And what the court described in that discussion is that a significant part of the diversity interest, as it was articulated by the schools throughout these cases, is that students from different racial minority backgrounds will have varied viewpoints on issues and discussions and add to the educational experience from that perspective as well. According to the court, however, that attributes stereotypes based on the ideas, viewpoints of individuals, irrespective of individual true experiences and perspectives. And so the court does not permit that sort of broad generalization to be used to justify racial classification. And fifth, and finally, there's no logical endpoint to the programs. The court, as the court said it, there was no end in sight to these programs being used. And absent the court's intervention, the court stated that it didn't believe that these programs were ever likely to end. The one phrase that you heard talked about a lot in this vein was from Justice O'Connor's opinion in the Grutter decision, which was the 2003 case that was previously on the slide, where she commented in her majority opinion for the court that these programs would not be needed 25 years after, which would put us at 2028. So the court, I think, obviously took that to heart. But in addition to that, the majority opinion articulated that there were several other times in the Grutter decision where part of the discussion was having some endpoint to the programs that were put in place. And the court didn't see that with respect to any of those decisions. So on those bases, sort of at a very broad top line level, those were the reasons that the court invalidated the race conscious programs as violating the 14th Amendment. Now, the majority opinion did not expressly overrule prior case law. There's not a section of the opinion where it says we hereby overrule Grutter or Bakke or any of the prior cases. That said, if you look to some of the separate opinions, they certainly characterize it as overruling prior decisions or effectively overruling the court's prior case law. And, whether they technically did or not, I think is probably a little bit of a distinction without a difference in terms of how we're talking about it at this point, because it is difficult to see at the very least how any diversity interest, at least how that diversity interest had been articulated in any of these prior cases, could pass muster on a compelling interest analysis as it's laid out in the majority opinion. So I think that effectively overruled is probably an accurate description of what the court ended up doing on the compelling interest point.
Michael, so let me take you into a little bit of the analysis that you're going to start walking us through. I'm really interested in hearing more about how you think the holding is going to practically be applied and some of the bumpers that the court may have put on its decision.
Yeah, and I'm going to turn it over to you two experts to talk a lot about that. These two quotes were in the final paragraph or the final two paragraphs of the court's opinion. And this is really, in my view, and I think in our view, our collective view, the source of what's going to be a lot of the discussion going forward, a lot of the litigation, how schools are crafting admissions policies going forward. So the Chief Justice indicated that there isn't anything that's going to prohibit colleges or universities from considering an individual analysis of individual candidates and how race has affected or impacted their life. But then in the next breath, the court goes on to say that, in essence, what can't be done in sunlight can't be done in the shadows either. So you can't use an essay or that type of analysis to simply subvert the court's ruling. And we'll get into some more specific discussions of that. But that sort of last two paragraphs of the opinion is critically important. And that's going to be the battleground for litigation. and the policy-making ground for what schools do going forward in terms of how they structure their programs. And before I let you all get into that discussion, I just want to make a quick note, because we're not going to discuss in detail all of the separate opinions. There are 237 pages worth of this, and everyone is obviously free to and encouraged to read those. They have a lot of important insight into how the court looks at these different laws, looks at the application, talks about the role that race plays in society today. There are important societal and policy arguments in there that are important and are critical to, our thought in these areas going forward. For purposes of this webinar, we're focusing on the majority opinion and the application of that opinion going forward, and looking to the practical implications of what race and admissions is going to look like going forward, and potentially some other areas where that's going to play out. So with that sort of summary, I'll turn it over to you and Derek to kind of lead us through some of that discussion.
Yeah, I'm happy to start this off. And Derek, I want to tee up the first question for you about what this is going to mean for admissions today. And as I'm looking through the questions that are coming in, I think that's where the focus for the audience is really what's this going to mean. So let me just give a little context and ask you the first sub-point of this. Really, I think this is asking the question of, should we be accessing race data based on our applicant pool? So if we've got this information available to us, we've collected it for a long time, whether it's through our own application process or if we're using some kind of an application system, should we keep looking at it, or is that going to be inherently risky? And for context, we know that the Common App, which is a system that a lot of schools may use, and some of those application systems that are available out there have offered to suppress that kind of data. The data is often collected, it's optional, it's self-disclosed by the applicant themselves. It may include race or ethnicity data, and the Common App's already responded to this case and said that we have the ability to suppress it. Other systems are following suit. But that also schools may want to access that at some point about their applicant pool, and that if they want it to be available, they recognize that there may be state or federal reporting requirements that data can be useful for, some institutional metrics that they're keeping track of, or other business needs. So institutions are going to have a choice now. I'm interested, Derek, you're a litigator, and I know you look at these kinds of issues through that lens, along with also practically trying to help schools weigh their other business goals here and maybe looking at this. Do you think it's inherently risky to have that data? Should we be considering it at all, and at what point?
Yeah, well, I mean, there's a number of great questions kind of built into that. And I think we have to start with what we know clearly cannot be done. And that is the Supreme Court is saying you can't consider race as race in the admissions decision. Can't do it. As a practical sort of artifact of this decision, that's off the table. So that sort of begs the question then, if you are collecting demographic and racial data as part of the application, why are you doing it? And you would need to articulate some rationale separate and apart from the admission decision, which is a prohibited rationale now. Some institutions might say, well, we want to know the general demographic composition of our applicant pool, because if we aren't getting enough applicants who are of certain racial groups, we need to do a better job recruiting them to join our applicant pool. And the Supreme Court decision doesn't foreclose efforts to recruit applicants. Efforts to market the institution to certain minority groups so that the applicant pool is diverse. But it does prohibit the consideration of race in the admission decision itself. So I think that on this question of do you collect the demographics or not at the application stage, you need to make sure you have a viable rationale for doing so, which can't be, we're going to consider that in making the decision to admit. And then you have to assess this sort of spectrum of risk and the utility of having that data. There is utility in having the data in assessing whether or not your applicant pool is diverse enough and whether you need to go out and recruit more diverse applicants. However, there's risk in having that data, especially if you don't screen it off from your admissions decision-making process, because it will allow someone to argue that as a matter of fact, you are still considering race, even if you're not explicitly saying so. And then you run afoul of the Supreme Court's directive that you can't do indirectly what we've said you can't do directly. So there's definitely risk here. The most risky scenario would be you collect the data and you make the demographic and racial data available to your admissions decision makers. The more conservative approach would be you don't collect it at the admission stage at all, period. And then the middle ground is you collect it, but you have some mechanisms to screen that data off from the people who actually make the admissions decisions.
I'm hearing no direct consideration of race in the process, and even accessing that data does create some risk and it needs to be screened off. Are there any circumstances in which the admissions process could somehow involve race as a factor? Are there any circumstances still allowable under this holding?
Yeah, well, and someone's made the comment that many schools are effectively open enrollment anyway. So you'll basically take any student you can get who meets the minimum sort of academic or other requirements. And for those institutions, this is sort of a moot point. But for schools that have a limited list of accepted applicants, or you might say have competitive admissions requirements, then this is why this question matters. And the Supreme Court has left a narrow window here, not to consider race as race, but to consider whether race has had a particularized impact on someone that therefore gives them an attribute that makes them desirable in terms of admissions. So you might say maybe you have someone who in their admissions application says, I've experienced a great deal of racial harassment as a minority, and as a result of that, I've learned to be resilient. And so when I face adversity, I can overcome it. And that makes me think I'm going to be effective at college. I can rise to the challenge given my prior experience as a victim of racism. Well, the institution can consider that this applicant should be admitted because they are resilient, because they can overcome adversity, but not because they are of a given race. So it's sort of the consequence, perhaps, of being a racial minority and the effect that that has on a given applicant. But note that that's an individualized assessment, and it doesn't rely upon a stereotype that all persons of a given race or ethnicity have necessarily had to overcome the same challenges. Or you could state that affirmatively, and you might, let's say, have an applicant who says, as a racial minority, I've come to appreciate the importance of growing diversity, and I want to be admitted to college because I want to work in this field where we need more persons who are diverse because we need to serve, populations. And so this is important to me. In which case, you might consider that this particular student, not just because of their race, but because of their own individualized desires, is going to be a very effective, whatever it is, social worker, healthcare provider. But that's an individualized decision based on their experience, not because they checked a certain box. That's what the Supreme Court has said you can't do. And then the last part of this is just, as far as recruiting and marketing, and someone typed in this question, which is, well, can we still basically have pipeline programs or partnerships with, let's say certain high schools where we're trying to go out and get diverse applicants to try to come to our institution? I mean, nothing in this decision forecloses a college or university from trying to recruit a diverse pool of applicants. Nothing in the decision prohibits a college or university from sending admissions recruiters out to certain high schools, let's say, that happen to have a large percentage of minority students. You're not conferring a negative or a benefit on someone. You're educating them about your institution, and you're inviting them to apply. Where it crosses the line is where you use race or a race proxy to then give someone a benefit or give them a negative. So just to illustrate the distinction, we were talking about this before. I mean, suppose you have a pipeline program where you send recruiters out to a high school in the urban core, and you're trying to get more students from that high school to apply so that you have a diverse applicant pool. I think that's permissible. But then if you also said, and for this school, and because there are so many minorities there, we're going to give you a special option to apply early that will, in effect, give you preference because more of you might get in when we have more slots. Now I think arguably you've crossed the line to where you're not engaging just in marketing, but you're giving a plus to someone on the basis of race, which if you're in competitive admissions land, necessarily creates a negative for someone else because it's zero sum, would say the Supreme Court. So I think those are some of the, the practical impacts on admissions. Again, for those of you who are open admissions and weren't considering race, a lot of this isn't an issue for you. What becomes an issue for you, and we'll talk about next, is does this decision affect scholarships? Does it affect hiring? Does it affect internships and other programs where race may be a category? But for those of you that are competitive admissions institutions, there are some real limitations, I think, that are apparent now in what the Supreme Court has done here.
There's perhaps one more area I want to make sure we cover before we move on to that next section, which is on marketing and recruiting materials, because what you've both highlighted is how fact-specific the risk can be. And that's certainly challenging for institutions as, if you're facing potential litigation, you're really thinking about, can you dispose of a case on summary judgment, meaning that you've done everything possible factually to comply with these and that you can get past summary judgment. One of the things that we've started doing is working with institutions and a few nonprofit education recruiting organizations in anticipation of this decision to review all of their internal and external, so external marketing materials, applications, admissions materials, things that students and the public need, but also internal facing materials that, for instance, an admissions committee may be trained on, or admissions guide, so that all of those line up, again, in anticipation of this decision, but now that we have it, certainly so that those materials do not create risk for institutions that are trying to mitigate it. When we do that kind of review, one of the things that we're often flagging as potential risks that need to be weighed against the goals of the institution are things I just call my action words, my verbs. Are we cultivating a diverse population of students? Are we growing? Are we building a diverse class? Those are the kinds of buzzwords that can create scrutiny. In my view, per se, are they violative of this holding? No. But perhaps they create some factual questions about what's happening behind the scenes. And the common criticism with admissions practices is it's a black box. That's what we hear in the media. We don't know what's going on behind the scenes. And when you have that kind of verbiage in some of these materials, it can raise eyebrows and potentially create challenges. So we're looking for those kinds of statements. And it's certainly worth looking at all of your materials. So if you haven't done so in anticipation of this holding, we're seeing a lot of schools looking to do that now, certainly in consultation with legal counsel. As a little bit of a sidebar for you Title IV aficionados like myself, it's a really good time to also look at these materials through other lenses, things like misrepresentation and consumer disclosures and all the requirements around Title IV. So just a little sidebar on that. It's a good time to do all of it together. But certainly we're seeing a lot of institutions and other recruiting types of entities take a look at their materials to make sure they're not factually creating some risk that they don't mean to create.
Yeah, so I think just to carry on that, Julie, this is a great point. If we can actually just go back 2 slides to the application of holding slide that Michael ended with, or almost ended with, a lot of people saw that first bullet and said, okay, well, there's still a way for us to consider the effect that race has on someone. But you've got to read that with the second bullet, which is the Supreme Court saying, we're not going to allow you to do implicitly or indirectly what you can't do directly. That second bullet opens up a whole field of litigation against institutions where even if you don't explicitly consider race, and maybe even if you say we don't consider it, but nonetheless you have verbiage sitting on web pages or in handbooks that maybe suggest you are, well, people can sue you and say, in practice, you are indirectly doing what the Supreme Court said you shouldn't do. And so what your suggestion, Julie, to say every institution should basically do an audit of their public and internal facing documents to make sure there isn't language in there that would give more fodder to someone to come and make this sort of claim, particularly if they paired it with statistical data maybe that showed that in practice, your admissions decisions are weighted in a certain way that supports the argument there's still some race-conscious decision-making happening here. So sorry to take us back. I wanted to illustrate the effect of that sort of language.
It's a very good point, and that's where our questions are taking us today, so I'm glad you took us back there. Let's talk a little bit more about what this means for admissions today. We've already seen some pretty significant trends on schools, what they're doing with respect to test scores. I think we've got a few things ahead about legacy admissions and what schools may be doing. Derek, will you talk us through a little bit about test scores, legacy admissions, and then where we probably going to need to land on our programs?
Okay. So, I mean, again, we're kind of getting back to a question of focusing on intent. The Harvard and North Carolina cases deal with the use of race as a factor in admissions. Race is a category that the Constitution and Title VI say generally we can't use, absent, meeting this very rigorous test. But we can think about non-race-based categories, and some of those non-race-based categories may improve diversity in a way that isn't directly tied to race, even if they correlate with race. And there's still room there for institutions to take non-directly race-based efforts to improve diversity. So, the first bullet here on test scores. Many institutions have already gone test optional or eliminated test scores as a factor in admissions. And one rationale for doing that is to say test scores are maybe not predictive or not as predictive as people think about a person's success in higher education. Or perhaps you might say there's certain groups of persons for whom testing, ACT, SAT test is simply not fair because of various reasons. And if your rationale as an institution is to say, we're going to go test optional or eliminate testing because of those reasons, it's not predictive, the methodology isn't sound, it isn't fair to a whole range of people, poor people, etc., that's allowable. Now, what if, though, next week you sat down in a meeting without a legal counsel and you said, we need to find a proxy because we can't use race anymore, but we still want to have racial diversity. And so if we eliminate test scores, we can see that we can pull down let's say Asian applicants by 20%, and we'll increase African Americans by 15 if we do this thing. And so that's what we're going to do. Well, that's doing indirectly what you can't do directly. So there's an intent element, I think, that will be important as institutions look at other things like test scores or legacy admissions, or maybe granting a preference to first-generation students. You need to make sure you have a rationale for doing so that is not simply a proxy for doing what you were doing before, but that you can't do now. Legacy admissions is one of these that actually you can sort of look at this two ways. One, you might say an institution is using legacy admissions as a proxy for race insofar as it benefits maybe white or Caucasian applicants. You could also have someone eliminating legacy admissions for the purpose of trying to do indirectly what you couldn't do directly. And that's going to get litigated. It's already being litigated at elite institutions where the legacy admissions, coupled with the zero-sum artifact of being competitive, can really cause differences in the racial composition of an admitted student body. And you can think of all sorts of other, what we lawyers would call facially neutral policies or practices. In other words, things that don't directly use race, but nonetheless could be used with a subjective intent as a proxy for race, whether in isolation or sort of compiled together. So as an example, nothing in this Supreme Court decision precludes an institution from giving a preference at admission to people who are economically disadvantaged. You can do that. especially if you say, we have a mission of serving people who don't have a family history in higher education because we want to improve people's lives, and this is one way to do it. Nothing in the decision precludes you from offering a preference to first-generation college students. The decision even says you can use geography, and many institutions use geography because you say we want to, serve people across the state, and so we want to have applicants and admitted persons from every county. And if the rationale for using those factors is legitimate, then you can continue to do so. If you sit down in a room and say we need to come up with 4 factors that will serve as a proxy for race because we can't use race anymore, but we want to have the same effect, and these are the ones that will do it, we can run logistical analysis and figure out that if we use these 4 things, it's effectively the same. Well, now you're operating in doing indirectly what you can't do directly land, and you face potential litigation liability if that's sort of the mindset and the rationale, especially if that's also partnered with emails or web content or other things people have said or published that would give fodder to someone to sue you for that reason.
And we were already seeing some of these cases start to work their way through even before the Supreme Court's decision in this sort of facially neutral, but there's some subjective evidence or subjective intent that it's being done for a race-based purpose. And so I don't think it will be long before we're seeing some of these cases start to make their way through the courts.
And what you're both highlighting, and I want to make sure for all of our institutions, especially our offices of general counsel who are on the line, is the sensitivity of the conversations that we know are happening on campus with admissions teams, maybe even within your colleges, certain departments that may oversee their own departmental admissions process. We know that those conversations are happening, brainstorming's happening as we're all trying to figure out how to maneuver with these decisions that we just got this past month. And so a lot of just brainstorming types of conversations can create risk with them. And so it's important to make sure from an in-house perspective, you're having those conversations carefully with your colleagues because the subjective intent often can be very well intentioned as folks are just trying to understand how to deal with the decisions of what might be possible and what's permissible. And that can be very well-intentioned conversation, but possibly happening on email. So we want to flag the sensitivity of these conversations that's happening. Derek, we've got a lot of questions on the next, what I know you're going to cover on the next slide, we'll cover together, but I just want to highlight for you, I'm seeing a lot of questions about, okay, we understand what you're telling us about admissions. We understand the holding. We've seen, how it's been reported in the media. We know we may need to make some changes if we're a competitive, selective institution with race as a factor. But what about all these other areas that perhaps weren't directly addressed in the holding and what might be the outcome? And scholarships is the number one I'm seeing in the questions that people would like us to cover. So if you're able to get into a little bit about what you anticipate, how this is going to affect institutional scholarships, I'll take on the employment piece.
Okay. Well, so we have to think back to what were the laws at issue that the Supreme Court was enforcing, if you will, in these cases. There's the Equal Protection Clause that says state institutions have to apply the law equally without regard to race, and Title VI that says institutions that receive federal money can't discriminate with regard to race with respect to their programs and activities. So both of those laws on their face cover a lot more than just admissions. And the offering of scholarships, that's a legal benefit, if you will, in terms of equal protection. It's a program or activity or operation under Title VI. So the reasoning of the Supreme Court in these cases, even though they're focused on admissions, is going to apply in the scholarship context too. And frankly, to cut to sort of the punchline, I think will make it very difficult, if not impossible, to have race-based scholarships. Even before the Harvard and UNC decisions, it has been challenging to have race-based scholarships survive complaints with the Department of Education or lawsuits. There was guidance in 1994 that said you can have a race-based scholarship really in one of three circumstances. One, if you as an institution have yourself discriminated against certain minorities, and you're going to use scholarships to remediate the effects of your own discrimination, you can do that. But that had to be discrimination that you could prove with evidence that you had engaged in, and it had to be your institution, and it had to be recent. Very few schools utilize that rationale, and I think very few would want to admit today that they have engaged in recent discrimination against minorities that would justify the use of scholarships to remediate their own discrimination. The second ground was to achieve the educational benefits of diversity, and that ground is effectively gone in light of the decision the Supreme Court issued last month. And then the final sort of scenario was, if there is an entirely separate entity from the institution that funds scholarships based on race, and all the institution is doing is accepting a check, then the institution can accept the check because it's not the institution that is administering that external program. So there's very little room here, and certainly I don't think there's room to rely upon the diversity rationale as the basis for using race directly in the award of scholarships. But in the same way that the Supreme Court has said, you might be able to consider whether race has resulted in someone having particular attributes that make them desirable, well, there may still be a path. Or where, we're saying you can maybe use non-race-based factors like economic disadvantage, geography, first-generation college student. You could base scholarships on those rationales as well, as long as you aren't doing it for the purpose of indirectly doing what the Supreme Court has said you can't do directly. So I think that we don't have a Supreme Court case directly applying this reasoning to scholarships, but it certainly seems that this reasoning is going to make it very difficult, if not impossible, for most institutions to have scholarships that are directly based on race, at least to the extent that those are scholarships of the school or that are administered by the school. So then I think another question,
Derek,
Julie,
I completely agree. I think this has been a risk. Go ahead, Derek.
Nope, you're fine.
Okay. It's been a very risky area for a long time. I have kind of used the phrase with respect to scholarships that include race as even just as a factor or as a preference, as putting an institution potentially in a sitting duck type of situation for a long time. And I think this holding only makes that exacerbates that risk. Just so we're really clear here, because I'm seeing a couple of lawyers ask essentially the same question in the chat. You said race-based scholarships would be essential. And I think we're taking the position here that, it's not a risk. It's going to be prohibited. What about race as a preference? Just to really drill down, what if race is just one factor of many, that decision's essentially the exact same? Do you agree?
Yeah, well, I agree with that. The cases involving admissions, race was but one factor among many, but nonetheless, it was a factor that was part of the causal chain, if you will. So I think any scholarship where race is listed as an eligibility factor, even if it isn't the sole factor, are, highly vulnerable. And, I see people chatting in, well, what if we have a donor agreement that says we have to use the funds to only, award it in this way? I don't really think that's probably going to be a viable defense for you in the end. If our reading of the Supreme Court decision is correct, then the Supreme Court's saying it is illegal to use race as a direct consideration in awarding whatever the benefit is, admission, scholarship, etc. And as a general principle of law, you can't enter into a contract to do something that's illegal. So there's going to have to be some hashing out of whether donor agreements are modified, whether funds have to be returned. There's a practical question of how does all that flush out, but I don't see the existence of a donor agreement being some sort of exception that sort of saves the institution from the effect of this decision.
And the other part of the analysis that plays into this too is even at your open enrollment institutions, scholarships are almost always going to fall into that zero-sum category, right? Because money's going to some students and not to other students. And so you're going to have many fewer situations where the zero-sum doesn't come into play, I think, in the scholarship realm.
Yeah, I think that's right. And a lot of institutions have looked at sort of the pooling argument as a theoretical way of maybe rebutting that. But I have I'm very concerned about whether that pooling argument is going to be enough to overcome this kind of this risk. Generally speaking, from a factual perspective, I don't often see financial aid administrators really being able to demonstrate that that was in some way eliminating the zero-sum argument here. So that risk is still going to be at play. So, Michael, I'm really glad you raised that. All right, let me, we're still seeing some questions on scholarships. We might circle back to that at the end if there's some time, but let me quickly get us into a little bit of another area, which is employment. After Grutter and Gratz and that era, we really saw higher education institutions uniquely sort of blend these concepts of diversity as a compelling interest in admissions. It started to bleed over into maybe that allowing us some flexibility with respect to diversity in hiring. And so I always think it's really important to remind everybody as employers, we need to be level set on what is allowable under the case law under Title VII. And there has never been a court that's held the diversity as a compelling interest, essentially to remedy some societal imbalance in an employment setting. And so we do see some of that bleeding over in academia because you're wearing multiple hats of admitting students and also serving as an employer. Mirroring racial representation in society is also not a recognized permissible use of race in the employment context. So when we're talking about race-conscious hiring, the allowances under prior case law has always been very narrow. Under Title VII, the compelling governmental interests that have been recognized as remedying effects of past discrimination. And as Derek already said earlier, with respect to other contexts, it's got to be very specific. It's got to be past discrimination that isn't remote in time. It's got to be specific to that institution. So an institution's essentially saying, in order to take advantage of this, we've been discriminating against our applicant pool in the employment setting for some time. Or remedying some manifest imbalance in a specific job, again, with a lot of specificity in being able to demonstrate that. And even then, any employer that was trying to take advantage of those compelling interests needed to make sure that their practices were narrowly tailored. And that's often when these kinds of affirmative action programs are essentially challenged, that employers often fall down in the case law as they're not able to show that it was narrowly tailored. So I just want to level set everybody that is the Title VII existing case law. And these holdings they don't directly address employment, certainly. But if we're extrapolating from where the court may go, we certainly see this risk as only exacerbated. That means that, more than ever before, this is high risk, and it was high risk before these decisions to be using race as a factor for hiring. The landmines then in academia have often been these are the things that we try to flag anytime we're being asked to look at faculty hiring practices, are things like reserved lines for diversity hires. That certainly is problematic, and only more so after these holdings. College or departmental diversity plans with any specific targets, any underrepresented minorities are trying to achieve 50%. Those are the sorts of things that can create a lot of risk with respect to faculty hiring. Evaluating administrators based on meeting goals for achieving diversity targets in hiring and promotion. Use of diversity statements in the hiring process, not per se, depending on how it's framed, discriminatory, but potentially creates some real risk. And certainly providing any additional resources to underrepresented minorities who actually cross the line and make it to actually get hired. So if they're getting extra signing bonus or some kind of startup package, salary supplements, anything like that, it then puts the entire hiring process in question. So those are landmines we've seen in faculty hiring, always have been high risk under Title VII case law, which applies to private and public institutions, but certainly even more so today. So the last one I want to make sure we're covering, Derek, I mean, unless you have anything to add on that, is other protected status. I'm seeing a lot of questions around gender and other protected categories and whether these holdings are going to affect us there too.
Yeah, so I mean, this is an area where we're going to have to probably wait and see how some of this plays out. So going back to what the Supreme Court said, it said that race is a particularly pernicious category of classifying people. And under our Constitution, whenever someone uses race, we have to have a compelling interest, least restrictive means. It's subject to strictest scrutiny. Well, other protected statuses like sex, like gender, are not necessarily subject to strict scrutiny under the Constitution. Some of them are subject to what's called intermediate scrutiny. Some of them are subject to what's called rational basis review. And so it remains to be seen, at least at a constitutional level, whether there's a little bit more room for institutions to consider some of these other categories in certain ways. However, and one of the things, if you read all these concurrences that are in the decision, there's one written by Judge Gorsuch, where he essentially says, we don't even have to look at the Constitution. We have a statute called Title VI that says you can't use race, period, full stop. It doesn't have any exceptions. I don't even think strict scrutiny is an exception to it. Well, Title IX precludes the use of sex in making determinations of institutional programs or activities. So you definitely see a skepticism in this Supreme Court decision about using categorizations, especially if they're based on stereotypical assumptions about how a person of a given category will behave or what they've experienced. And so I think there's general vulnerability to using classifications to award benefits, whether it's admissions, whether it's scholarships. But these other categories are a little bit different insofar as they aren't subject to strict scrutiny in the way that race is. And just to clean up, I think we maybe had a typo in one of our earlier slides that used the Roman numeral 9 instead of 6. But the Supreme Court decision that we presently have has not addressed whether Title IX-based affirmative action is viable or not. It's Title VI. But it sort of remains to be seen in these other protected statuses, how that will all play out. Gosh, Julie, we've got a lot of questions. We've covered some of these, but I wonder if we have time maybe just to pick one or two more that are of interest. A number of people have said, well, what about affirmative action plans in hiring? And this is one of these kind of misnomers where people use affirmative action plans in different ways, maybe without knowing it. There's the affirmative action plan under Title VII where you're trying to use race to explicitly remediate your own past discrimination. And I think we've kind of covered that. But affirmative action plans can also be used, especially in some of the contracting requirements, to mean that an institution is taking affirmative efforts to recruit more applicants, to improve the odds that it will be able to hire applicants by having a more diverse pool, but it's not using race as such in the decision to hire. The Supreme Court decision doesn't foreclose affirmative action plans that are of the type where you're trying to improve the diversity of your pool, in the same way that I don't think it forecloses colleges or universities from recruiting a diverse pool of student applicants. But you just have to be careful when you say affirmative action plan, what it is you're referring to, because some people do use that phrase to refer to a program that explicitly considers race in the hiring decision. And those are going to be, subject to very strict scrutiny, as Julie highlighted.
That's right. Well, Derek, we are just at time, so I do see that there are a number of questions that we were able to get to. Some we have not been able to, so we will try to follow up with you for those questions that we weren't able to cover today. I want to thank everyone for joining us. We hope the information was helpful to you and your institution. As a reminder, the program has been approved for legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including a course number, will be emailed to you tomorrow, along with a recording of the webcast for watching and for sharing with your colleagues. Please be sure to complete our short survey. We do use that feedback to plan for future programs, so we really do appreciate you completing that. It only takes a minute. This concludes our webinar. Thank you, everyone, for joining us. Take care.